do mediation when we're in the middle of a pandemic?
Yeah, absolutely. So it's a really relevant question that I've been getting lots of emails about today. Mediation is available to happen online via video link, Zoom, exactly what we're using right now. And I've actually had a really helpful email from my mediation, what's called PPC, which I think is sort of your practice consultant, something like that, these sort of initials they use. Every mediator will have one, and she sent a really helpful email around just assuring everyone that she is actually going to be moving to doing online mediation now for the next 4 weeks. She's obviously going to monitor how that goes, and just encouraging us all to let clients know that that's something that we are able to offer, and also just really helpfully saying that she's happy to do some kind of free training with us well if we want a kind of refresher on how to conduct online mediation. So it's very much at the forefront of our minds as to how we can help people in this kind of strange, I guess, extraordinary circumstances at the moment. But yes, we can certainly offer clients mediation help whilst this is ongoing.
Could online mediation actually be beneficial, given that it's always best to be in a room together? That's often the swiftest way to come to a conclusion and to cut a deal, if that's what you're doing with the finances. But if you've got a very difficult relationship, perhaps, where otherwise they might not want to be in the same room together, I know there's options like shuttle, but let's tell us a little bit about those options, because I think people don't realise how many different ways they can do mediation.
Yeah, absolutely. So again, another email that I had today was actually telling us about different online solutions to offering shuttle mediation. So I believe there's various apps where we could offer shuttle mediation, where you can sort of call people in for sort of certain parts of the meeting and add and join them as and when is appropriate. So they're certainly looking at how shuttle mediation can also take place remotely. But in terms of mediation happening sort of remotely rather than us all sitting in the same room, and whether that's going to be more beneficial, I think, like everything with mediation, it's on a case-by-case basis. And if clients feel comfortable and that it's going to be productive for them to have an online session and it will help them feel like things are progressing for them in this uncertain time, then that's absolutely fine. We as mediators can offer that. But equally, I think there will be some clients where they will feel actually they're not able to make the same kind of progress in person, sat down in the same room, that they would be able to online. And equally, that's absolutely fine. That's really one of the benefits of mediation, and it is that it's entirely flexible. So we can accommodate clients depending on their different concerns.
So just to summarise, they could be mediating online, so safe in their own space, perhaps with someone there supporting them if they're emotionally distressed, and you would be able to manage that power balance between the two parties or more, if it's other members of the family involved, through something like Zoom. But when you were saying also, just to clarify, with the shuttle mediation, you were talking about spending time with them online and then going over to see someone else, so they're not even seeing each other at the same time online, if that's perhaps a more extreme situation.
Yeah, exactly. That's certainly something that we'd be able to do as well, and it would be, again, just sort of tailoring it to different clients and what they feel comfortable with in these circumstances.
And would you say that that's particularly appropriate to someone who's perhaps in a very, what they would perceive as a controlling relationship, or where there've been domestic abuse, for example?
Yeah, so, well, I think, where there's domestic abuse, mediation isn't necessarily appropriate, and most of the time that's something that we would flag up with them before we would even consider having a joint session. So I would hope that any couples where domestic abuse is an issue, they wouldn't really be in a situation like mediation, because that's not necessarily going to be appropriate if they feel unsafe. But if perhaps there had been issues of domestic abuse, perhaps historically, and that had kind of been, I suppose, capped, or they've worked through that, and it wasn't such a present issue, then they felt able to mediate, then perhaps doing it remotely may be more appropriate for those couples. Yeah, they may feel safer.
Thank you. And is there anything else you'd like to put right to people who you must have people asking you all kinds of questions about mediation, and getting confused about even what it is? Would you be able to perhaps give 2 or 3 common misconceptions and correct them for us?
Yeah, absolutely. So I think the first misconception would be that I have to go to mediation. I think that's probably the worst thing that people say to me, because I think there is, of course, that misconception that it's kind of like a tick box exercise that they need to do before they can go ahead and get into their sort of fight in court proceedings. So that's, I suppose, the most common misconception about it. No one's going to force you to mediation. It's very much a voluntary process. So I think that's number one. And then I think the second one would be that it's like therapy. I think lots of people think mediation is where we're trying to get them to reconcile. And again, of course, that's not the case. It's very much us just trying to facilitate communication between them so that they can go ahead and negotiate a settlement rather than kind of get them to reconcile together. So I think it gets confused perhaps with relate kind of therapy sometimes in my experience.
No, I often come across that myself. It's amazing that it still persists. Just before we move on to Emma, who's waiting very patiently there, can I just, I mean, you're welcome to tell me I'm wrong on this, but when there is a domestic abuse situation, my assumption was that obviously sitting in the same room with someone, that's not going to work. But because of the option of shuttle, if they can be in the same building safely, or when it's physical, or when it's times like these when you want to be using online, that does allow an option. It all depends on the power imbalance, because often it might be a situation where you're co-parenting, you still got to co-parent, still got to swap the kids over, you still got to cut a deal with the financials, and that I'm always keen to encourage people to not just immediately write off mediation as an option, especially when you've got the online option. And it depends on whether the mediators decides that they feel that would work with that particular couple, but not to immediately write it off and then go to court, which of course at the moment that's going to be a bit tricky. So what are your thoughts?
No, shuttle mediation.
So and doing online, would that be possible in that way, or am I being sort of overly optimistic?
No, it would be. And again, it's very much up to the couple themselves. And then it's obviously to the mediator. So if they feel comfortable mediating, say if it is either online or by way of shuttle mediation, if there is a history of abuse, that would be the first step to ensure that they're both happy. But then secondary to that, it would be for me to obviously manage and kind of assess, I suppose, the risk to both parties, and just make sure that I would be comfortable mediating in that situation. If perhaps I didn't feel comfortable doing it because I was concerned about the risk, I would always consult with my PPC, my consultant, as I was saying there, and she may either say, because perhaps she's more experienced than I, that she would feel comfortable either co-mediating with me on it if I didn't feel comfortable, if I was unsure, or she would either sort of take on the case herself if I wanted to refer it to her. So there's lots of different options. It wouldn't be the case that we turn people away and simply tell them to go to court.
And the last question is is it possible if someone is open to the mediation but fearful, distressed, would they be able to have perhaps a counsellor or somebody who's giving them emotional, psychological support, providing that was a professional who had your backing because you knew they weren't going to interfere in any way in the process, and obviously that the other party as well, the spouse, was also happy for them to have that person just supporting them, just sitting with them with a cup of tea, for example, on that basis? Would that be a possibility?
Absolutely, yeah. And I think in lots of situations that is really beneficial, where someone will feel that actually they're more comfortable communicating with someone by their side, just having that moral support. But I think the key with that is obviously making sure the party who doesn't have support is happy and they don't feel that there's an imbalance, because really the key with mediation is ensuring everyone's on a level footing, and that there's no imbalance there. So that would be my concern in that situation, is just to ensure the party without any support was completely comfortable with that.
That's brilliant. Thank you so much for highlighting that. Emma, welcome. Just before, Alice, please tell us your full name, a little bit about the firm and your role with Stowe Mediation. Stowe Family Law as a mediator.
Yeah. So my name is Alice Wightman. I'm one of the senior solicitors and mediators at Stowe. I work in the London offices. I divide my time between the Chancery Lane and the London Victoria office. And I've worked with Stowe for about a year now. So I do a mix of solicitor work and also mediation, and I also get involved in a sort of collaborative process as well, being a member of Resolution's collaborative working party.
That's great. I might ask you a little bit about that in a minute as well. So hello, welcome Emma. Perhaps you could start as well with just telling a little bit about yourself and your role at Stowe Family Law in Esher.
Hi, I'm Emma Newman and I'm the managing partner of Stowe Family Law's Esher office, and I'm currently covering the managing partner role in the London Victoria office as well, while our managing partner in Victoria is on maternity leave. I deal with all aspects of family law, mainly finances, but an awful lot of children work as well. I'm an accredited member of Resolution in complex financial matters and children matters.
Thank you. And now the role of family law solicitor, it can depend on what people's needs are. So for example, I know that it can have a concierge role, if you like, that you can help people right from the beginning all the way through the process. Other people might be in a situation where financially they need to pick and choose a little bit. So could you sum up the key times when you absolutely should be talking to a solicitor?
I would say in almost every single case, the first step should be to go and see a family law solicitor, preferably somebody that's been recommended to you, preferably somebody that is a member of Resolution. It's arming yourself with information, and information is power, and a good lawyer will give you all of the options, and they will advise you as to what's in your best interest. Every case is very, very different. In most cases, I will be recommending that a couple go and try and resolve their financial issues and children issues in a forum like mediation, some sort of ADR. For some clients that might not be appropriate, and we might be suggesting that negotiating between solicitors might be better. And there are some cases where, not very many, but there are some cases where you might think you need to make an application to the court straight away, but they are definitely in the minority.
And perhaps you could share with us from your own experience with those that do end up in court. Would you say that sometimes people ending up in court who really shouldn't be there? It's their emotional, psychological anger. It's not a logical reason why they're there. That in theory they should be able to cut a deal and sort things out, but other things seem to have got in the way.
Absolutely, it happens all the time. You have a lot of cases where it should never get to court, and it's the worst possible place to sort things out. It's really stressful, it's really expensive, and the end result is really unknown. It's a bit of a lottery. But if you have got one party that is not being sensible, perhaps they're not being advised properly, perhaps, or they might be in person and they don't know what the law is going to deliver. They pursue it through, you've got no choice but to apply to the court just to get the right results.
At the end of the day, you have to do what your client asks. I guess it's part of the job, but you can lead a horse to water. You can't force it to drink. So when it comes to the court, there's often many misconceptions around what it's like. People think, oh, the judge is going to listen to my story and I'm going to be shown to be right, and all kinds of interesting ideas about what it's about. Could you put people right on some of the sort of the basic facts of what they should expect if they do end up arguing in court? Okay,
so in relation to financial matters in particular, you often have clients who believe that they are going to have their day in court, and that's a phrase that's used very often, that they are going to be able to tell the court all about their partner's appalling behaviour and what has led them to that point. And it isn't like that. There are certain factors that a court takes into account when they're sorting out the finances of a marriage and how somebody's behaved within that marriage, whether they've had an affair. It's actually very, very rarely is it ever relevant. It's all about what the assets are, what the parties' needs are, and what is fair ultimately. And there is never ever having a day in court. I think people who go into the court process expecting that will come out very, very disillusioned.
Thank you. And also from a cost perspective, is there sort of, I know it's hard to put a number on it, but is there a sort of minimum that on average, that if everything breaks down, if mediation is no longer pursued and you decide to go to court, what's the kind of expense that you should be expecting right from, at the very least?
It's really difficult to say, because in financial proceedings there can potentially be 3 hearings if you end up at a final hearing, and in worst case scenarios you could have some interim hearings as well. But many cases sort themselves out at the first hearing, and your costs will be at the lower end of the spectrum. And when I talk about spectrums, the spectrums can be very different from case to case as well. You can have a really straightforward case with very clear assets, very straightforward assets. But you can have cases where the assets are really complex and take a lot of investigation, and that adds on to the costs. I think even if a case sorted itself out at the first hearing, I'd be very surprised if you would have costs of less than several £1,000s, and I'm talking sort of possibly 6 to 8. I don't think, I think that would be an absolute minimum. Yeah. But if matters go through to a final hearing where you've had potentially 3 hearings, we're talking about 5 figures in those situations as an absolute minimum.
Yeah. And it's important for people to know that, because it can help them make wiser decisions. I think they can be often confused about how much it's going to cost. When I talk to people, I always say one of the most important times to speak to a lawyer, a solicitor, is after you've cut your deal, ideally through mediation, or and you've got your financial agreement, and that needs to be turned into a legally binding consent order. And there's certain things that people should do, isn't it? Like get independent legal advice, get it turned into a legally binding document. Could you just take us through briefly that sort of process? So let's say, from the point of view, just work with Alice. She's done a wonderful memorandum of understanding to sum up what's been agreed. What would you then do as a solicitor at that next stage?
So I'd actually say, ideally, a solicitor should be involved earlier than that, because whilst the client is going through mediation, because I think the worst thing to happen is to be instructed by a client who comes in and says, we've reached an agreement, and you look at it and you realise that it's not workable for whatever reason. The mediator can't advise the client. It's important to have legal advice while you're attending mediation. But that advice doesn't need to be very expensive. It doesn't need to be very, very involved. It's just a gentle steer. It's remember certain aspects. It's focusing the client's mind on what is important. Once an agreement has been reached, the mediator will draft what's called a memorandum of understanding. They'll come in to see the solicitor, and the solicitor will look at the disclosure that's taken place in mediation, look at the agreement that's been reached that's set out in the memorandum of understanding, and advise the client on the intricacies of it. We'll look for perhaps things that might not work, and we'll explain it to the client in a lot of detail. To somebody that's not a lawyer, some things might not be apparent to them. They might not be aware that there's a maintenance clause, but it can be varied upwards and it can be varied downwards. There's things like that it's really important that their client's advised on. But assuming that it is all workable, it seems a sensible agreement, the solicitor will then convert that agreement into what's called a consent order. And that's the document that's ultimately submitted to the court. At the same time, the clients need to disclose their financial circumstances in a very brief document, in summary form. It's called a statement of information for a consent order. And ultimately, these documents are then sent off to the courts. They're put before the district judge, and it's up to the district judge as to whether it is turned into a consent order ultimately. It's not up to the parties, but assuming it's a fair agreement, then I'd be very surprised if the judge rejected it, and then the court in most cases approves it, and it becomes a binding order.
Thank you. And what are the kind of big mistakes from a legal perspective that people often make? I mean, certainly you've said one is that they come to an agreement that actually they haven't had any legal advice around and isn't workable and the court's not even going to accept it, that's clearly an area why, and I know that often mediators would say, you encourage people to tap into some legal advice at various points to make sure things are on track and correct. And obviously working with Alice, that's going to happen automatically. Well, are there any other sort of big mistakes that people quite often make, or even small ones that have consequences?
Yeah, I think one of the mistakes I see quite often is when people come to see me for the first time, they tell me that they've already got an offer on the family home, or they've already put in an offer on a property they really, really want. That makes things very, very difficult, in that there's pressure to deal with things really quickly. One party, it makes the negotiating power between the parties quite imbalanced, and that's quite difficult, because one party might feel inclined to accept something that might not necessarily be fair, simply not to lose a buyer, not to lose a purchase. So I would say the main thing is, do not even think about putting a property on the market for sale until you're very close to reaching an agreement, because that process can take a long time. And you don't want to annoy estate agents and potential purchasers, and you don't want to put yourself under unnecessary stress in what's already a really difficult, stressful situation.
And is it also possible that sometimes that during the negotiations that they discover actually that selling the house isn't the right thing to do, or the best option, because they haven't really done the sums and look forward at the financial situation clearly? Does that sometimes happen?
Yes, occasionally. I mean, that is one of the aspects that you want to receive advice on. Is this a case where the house can be kept or by one party, or is it a case where it has to be sold? That's a key part of it. Sometimes it's really obvious at the outset that one or the other, it will be transferred or sold, but sometimes it isn't, and you need to work through it all. Work through the disclosure, work through what there is, because it all depends on so many different factors.
Thank you. And just want to ask you both, actually, but I'll start with you, Emma, about the divorce financial workshops and sponsoring the event, which is going to be obviously this next one's going to be online, but normally we do gather people together in a room. Just say a little bit about why you feel that this is a useful event for people who are coming along and haven't met you at all, and perhaps have lots of poor ideas about what mediation actually is, so they get to meet Alice as well, right through to perhaps some of your existing clients who I know from the divorce show, met one who said, oh, they're my lawyers. She wanted to come along, which is lovely. As at any stage of divorce, why that kind of this kind of event can be beneficial from your perspective.
I think it's about education, and it's about knowledge, in that they are going to be arming themselves with even more information. I think another part of it is knowing that we as mediators and lawyers are human beings. I've been through it myself, which I think helps it quite a lot. We really understand that people aren't just going through a legal journey. They've got practical issues and they've got emotional issues, and we want to support them with those as well. And I think, bearing in mind it's a workshop, there will be other people there that are going through exactly the same things as them. And I think knowing that you're not alone in the process really, really probably helps quite a lot. Yeah,
no, I agree. And also, even luckily with Zoom, we can bring others in, and people will be able to do Q&A. So they'll be talking to you on the question answer panel. And anything else you want to share that you think is important for people to know, or do you think we've covered most things?
I can't think of anything at the moment.
If you think of anything, feel free to chip in. So Alice, just wanted to ask you about these kind of events that we're running, divorce financial workshop, as a way to not just help people plan forwards with the finances, but to become aware of the number of choices that they've got in dispute resolution. I mean, we've talked about mediation, but you also mentioned collaborative law, which most people have never even heard of. It'd be great if you could just let us know a little bit about that.
Yeah, sure. So the collaborative process is essentially where two lawyers work together and have what we would call a roundtable meeting. So it's similar to mediation in the same way that you have the benefit of matters getting underway sooner rather than later in terms of waiting for court proceedings. You don't have to wait for that hearing date. We can set a date and be flexible to the couple as to when they want to set their sort of roundtable meeting. But also so that they have the benefit of having legal advice alongside the negotiations. So often what people don't feel comfortable with about mediation is that they don't have legal advice then and there whilst they're going through that process. And certainly what normally happens is that as a solicitor, I find that clients will call me up after a mediation appointment and just kind of run through what has happened, whether what the other party has proposed is fair, etc. But some people don't necessarily feel comfortable being unarmed, I suppose, is how they would see it in that meeting. And the collaborative process is essentially that same roundtable feel, but with your legal advisor there. It's also suitable for those who don't feel that they're able to necessarily communicate whilst the other party is in the room. They don't feel that they have the confidence to kind of put forward their arguments. So essentially we take over that role for them where they don't want to speak, they don't want to have any kind of communication directly, and we would be able to do that on their behalf. So it's quite beneficial in that way. And kind of contrary to that as well, I often have it in cases where parties do feel like there is something that's really kind of burning that they do actually want to say and get across to the other party. But aside from that, all the sort of legal points they want to leave really to the lawyers to kind of say. But it can just be a space in which they'll feel heard, that they've got kind of the overarching kind of, I suppose, point that they want to get across of how they want to resolve this dispute, and it lets them feel heard, I think. So it works both ways, really. It's beneficial.
So what I just wanted to finish off with is, with collaborative law, we often describe it as you've got both your lawyers next to you and they talk to each other, and you don't have to send letters, they talk to each other. They're there to help you cut a deal and support you, and people often think, what a sensible idea, and wonder why it's so little known about. So I hope that through the workshops, more people will become aware of it as an option.
Yeah. I must just also clarify, just because it's not completely clear, I'm not actually collaboratively trained. I'm not a collaborative lawyer, but I am a member of the working party with resolution, just because I do a lot of roundtables. I can see how beneficial they are. And I think, like you say, it's not a kind of well used sort of, I suppose, type of dealing with disputes. So I'm not formally collaboratively trained, I should say. Let you know.
Does Stowe Family Law have collaborative lawyers though?
I believe so, yes. I'm sure there are some, yeah.
But at least you can, and you and Emma can both make sure people understand all the different options.
Yeah, exactly.
And work out what's going to work best for them as a couple. Yeah. Thank you so much for your help. I'm just going to finish with one question each very quickly before it time's out on me here. Why do you do what you do? Why did you choose this profession?
Do you want to go first, Alice?
I don't know. I was kind of waiting for you. I don't mind.
You want me to go first?
Yeah, I don't mind.
Why do I do what I do? I love my job. I'm passionate about my job. It sounds really silly to say I like helping people, but I really do. It's a job.
That's exactly what I was going to say, and I thought, how can I not say that in a corny way?
But it's true. It's so lovely to see somebody go through the whole process, and sometimes you see these complete transformations in people's happiness and people's lives. So it's so rewarding, and it's brilliant. I love it. Yeah.
Thank you.
Yeah, I would say exactly the same. It's just about helping people, really, and I think using I kind of like the facts and the figures to apply that to actually the kind of analytical side of it, to actually help people who don't really enjoy that sort of thing, and you can help them kind of move on to the next stage of their life. It's going to be much better for them. It's amazing the way that you see them kind of go through that process and kind of come out the other side. It's really rewarding in that sense. So that's kind of what I would say. I'm also quite nosy, and it's quite like, that sort of side of things.
You certainly get deep into people's lives, don't you?
Yeah.
At quite a fascinating time of their lives as well.
Yeah.
And what, just to round up very quickly, literally 30 seconds, what's your expectations of the workshop? Because you've not been part of one of the divorce financial workshops before. So what's your expectations? What do you hope to get out of it, or to put into it, shall we say?
Yes, I really hope that it takes some of the fear away, because I think anything surrounding law or kind of the legal process, whether that is mediation as well, I think can seem really daunting to lots of people. And I think as soon as you discuss getting lawyers involved, a lot of people have a kind of knee-jerk reaction of suddenly it's going to be really expensive, really scary, really aggressive. And I really hope that we can sort of remove some of that stigma, really. So I think that's really what I would like to get out of it, and put a face to the process, because I think actually it's one of the most personal things that you're going to be going through is divorce and separating. And actually it's important that couples have their trust in me as a mediator, that I'm the right fit for them, really. So I think it's about putting a face to that, really.
Thank you. That's brilliant. Thank you so much. And just in literally 30 seconds, Emma, what do you hope to people to get out of the workshop?
Similar to what Alice said, but I think it's about coming out of the workshop feeling so much better about their position. If we can do that, then we'll have had a good evening, I think. Perfect.
Thank you so much, both of you. I'll see you then. Bye then.
Bye.